House Democrats are wasting no time in their investigation of U.S. President Donald Trump, saying they'll hear directly from the whistleblower soon. It was his or her complaint that led the House to launch the impeachment inquiry of the president after he asked Ukraine's president to dig up dirt on political rival Joe Biden, allegedly in exchange for military aid.
That whistleblower will be allowed to come in without a minder from the Justice Department or from the White House to tell the whistleblower what they can and cannot say. We'll get the unfiltered testimony of that whistleblower.
This is absolutely devastating for Kash Patel. And I'm not talking about some minor legal complication that he can brush off with a good lawyer and a press statement. I'm talking about a federal court essentially opening the door to his potential arrest and prosecution, clearing away the legal obstacles that might have protected him, and creating a pathway where Congress could literally have him dragged into custody if he continues refusing to cooperate with their investigations. The FBI director, who thought he was untouchable because he has Trump's backing, just discovered that courts don't care about political protection when you're obstructing legitimate congressional oversight and potentially committing perjury under oath. But real quick, if you want to stay ahead of the headlines, please subscribe because you might think you are but aren't. Your subscription actually matters here. That's why we built Patrick Smith Show to bring you real stories, real context, and no corporate spin. All right, let's get back into what just happened to Kash Patel. So here's the situation that Patel now finds himself in, and it's genuinely one of the worst possible scenarios for someone in his position. Congress has been demanding that Patel testify about multiple issues, including the Epstein files that he's been stonewalling on, the political purge allegations at the FBI where he's supposedly firing people based on their past work on Trump investigations, and the Charlie Kirk assassination case where he made that false public statement about having a suspect in custody when they didn't. And Patel has been refusing to fully cooperate, giving those "I don't know" answers to everything, claiming he hasn't been briefed on details he should absolutely know about as FBI director, basically obstructing at every turn. Share this video with everyone you know because Congress finally got fed up with Patel's obstruction and started threatening him with contempt charges, which is the legal mechanism they have to force witnesses to comply with subpoenas and testify truthfully. And Patel probably thought he could keep stalling, keep saying he doesn't know things, keep hiding behind executive privilege claims or national security justifications or whatever excuses his lawyers came up with. But then a federal court issued a ruling that changes everything about Patel's legal situation and makes his obstruction strategy suddenly much more dangerous. The court ruled on a challenge to Congress's contempt authority, and here's what makes this absolutely critical for understanding why Patel is now in serious jeopardy. The ruling essentially affirmed that Congress has broad power to enforce its subpoenas, that witnesses can't just refuse to cooperate because they claim executive privilege or because they have political backing from the president, and that the mechanisms Congress has for compelling testimony, including the potential for arrest through inherent contempt, are constitutional and can be used when witnesses obstruct legitimate oversight investigations. Make sure you're subscribed to Patrick Smith Show because what this ruling does is remove the legal fig leaf that Patel might have been hiding behind, thinking that courts would protect him from Congress's enforcement powers or that executive privilege would shield him from having to answer uncomfortable questions about his conduct as FBI director. The court basically said no, Congress has legitimate oversight authority, witnesses have to comply with subpoenas, and the enforcement mechanisms, including potential arrest, are available tools that Congress can use when witnesses refuse to cooperate with legitimate investigations. Now let's talk about what inherent contempt actually means, because this is the nuclear option that Congress has been discussing using against Patel if he continues his obstruction. Inherent contempt is Congress's own power to enforce its subpoenas without going through the Justice Department or the courts, and it works like this. If Congress votes to hold someone in inherent contempt, they can direct the Sergeant-at-Arms to literally arrest that person, bring them before Congress, and detain them until they agree to comply with the subpoena and provide the testimony or documents that Congress is demanding. This isn't some theoretical power that exists only in history books, even though it hasn't been used successfully in decades. This is actual constitutional authority that Congress has, and members have been openly discussing whether to invoke it against Patel specifically because of his continued obstruction on multiple fronts. And what this court ruling does is confirm that Congress has this power, that it's constitutional, and that witnesses can't escape it by claiming they're protected by their relationship with the president or by executive privilege or by any other legal theory that might have created uncertainty about whether Congress could actually follow through. Think about what that means for Patel's situation right now. He's been stonewalling on the Epstein files, refusing to release documents that Congress has the legal authority to demand, claiming that the review process is ongoing and that he hasn't been fully briefed even though he's the FBI director. And those files are literally in FBI custody. He's been obstructing inquiries into the political purge at the FBI, saying he doesn't know the people he fired even though there are lawsuits with documentation showing he personally made those decisions. He's been unable or unwilling to explain the false statement he made about the Charlie Kirk case, claiming he doesn't remember the details of one of the highest profile investigations in the country. And Congress has been documenting all of this obstruction, building a record of Patel refusing to cooperate, and warning him that continued refusal will result in contempt proceedings. And now this court ruling comes down and essentially tells Patel that if Congress decides to move forward with contempt, if they vote to invoke inherent contempt and have him arrested, the courts aren't going to stop it. The legal path to Patel potentially being arrested and detained by Congress is now clear, and he can't hide behind executive privilege or political protection or claims that Congress is overstepping its authority. And Patel's response to this development tells you everything about how seriously he's taking this threat. According to sources, Patel has been in emergency meetings with his lawyers trying to figure out his options now that the court has cleared the path for Congress to potentially arrest him. He's apparently been reaching out to Trump asking for help, asking for protection, asking Trump to intervene somehow to prevent Congress from following through on contempt proceedings. And Trump apparently doesn't have good options for how to help Patel in this situation because this is Congress exercising its own constitutional authority, not something the executive branch can easily block. The timing of this court ruling is particularly significant because it comes right as Congress is ramping up pressure on multiple fronts related to Patel's conduct. The Epstein files deadline has passed, with less than 1% of documents released, despite Patel claiming thousands of FBI agents were working on the review. The bipartisan group of senators demanding an audit of the review process is getting more aggressive in their criticism. The lawsuits from fired FBI officials are moving forward with discovery that's going to expose Patel's decision-making process. And now, this court ruling removes one of the potential obstacles to Congress actually following through on contempt if Patel continues refusing to cooperate fully. Make sure you hit that subscribe button because here's where Patel's situation gets even more complicated and dangerous for him. It's not just contempt that he's potentially facing. There's also the perjury exposure from all those I don't know answers he's given under oath to Congress. If prosecutors or Congress can prove that Patel actually did know things he claimed not to know, that he was briefed on matters he said he hadn't been briefed on, that he lied under oath about his involvement in decisions he actually made, then each false statement potentially becomes a count of perjury. And perjury is a federal crime that carries real prison time, not just political embarrassment or contempt sanctions. So Patel is potentially facing both contempt proceedings that could result in his arrest and detention by Congress, and also criminal perjury charges if his testimony is proven to have been false. That's a vice closing from multiple directions, and this court ruling just made the contempt side of that vice much more immediate and real, because it removed the legal uncertainty about whether Congress could actually follow through. Think about the calculation Patel now has to make, because he's essentially trapped between terrible options. If he continues stonewalling and refusing to fully cooperate, Congress can now move forward with contempt, knowing that courts have affirmed their authority to do so, which means Patel could actually be arrested and detained until he complies. If he starts cooperating and providing full testimony and releasing the Epstein files, he potentially exposes himself and Trump to damaging revelations that could create massive political and legal problems. If he tries to thread the needle by providing some cooperation but not full cooperation, he risks satisfying nobody and ending up facing contempt anyway, while also providing enough information to create problems. There's no good option for Patel in this situation, and that's exactly why he's apparently screaming at his lawyers and desperately reaching out to Trump for help, because someone who thought they were protected by political connections just discovered that courts and Congress have power too, and that power can be used against FBI directors who obstruct legitimate oversight regardless of whether they have the president's backing. Share this video, because the broader pattern here is significant beyond just Patel's individual predicament. This represents courts affirming that Congress has real enforcement power, that witnesses can't just stonewall with impunity, that political protection from the president doesn't shield you from congressional oversight authority, and that has implications for everyone else in Trump's administration who's been refusing to cooperate with congressional investigations, thinking that they're safe because Trump will protect them or because the political dynamics make accountability unlikely. If Congress actually follows through on contempt against Patel, if they vote to invoke inherent contempt and have him arrested, that sends a message to every other Trump official who's been obstructing oversight. That message is you can be held accountable. Congress has real power to enforce its subpoenas, and political backing from Trump doesn't make you immune to consequences. That could potentially open the floodgates to Congress using its contempt power more aggressively against other officials who've been stonewalling on various investigations. And the specific issues that Patel is obstructing on make this particularly significant. The Epstein files are something the public desperately wants to see, something Trump promised to release, something that Congress has legitimate oversight authority to demand. Patel's stonewalling on those files isn't just bureaucratic foot-dragging, it's actively preventing Congress and the public from seeing evidence about powerful people's connections to a convicted sex trafficker. If Congress uses contempt power to force release of those files, that's using congressional authority to break through a cover-up that serves powerful interests. The political purge allegations at the FBI are about whether Patel is turning the Bureau into a political weapon, firing people based on their past work investigating Trump rather than based on legitimate performance issues. Congress has authority to investigate whether an executive agency is being weaponized for political purposes, and Patel obstructing that investigation by claiming he doesn't know people he personally fired is obstruction that prevents legitimate oversight of potential abuse of power. What happens next depends on whether Congress actually follows through now that courts have cleared the path. If they vote to hold Patel in contempt, if they direct the sergeant-at-arms to arrest him, if they actually use the inherent contempt power that this court ruling has now affirmed, then we're in unprecedented territory for modern American politics. An FBI director getting arrested by Congress for refusing to cooperate with oversight would be a massive constitutional moment, and it would demonstrate that congressional power still means something, even when the president tries to shield his appointees from accountability. If Congress backs down, if they don't follow through despite this court ruling clearing the way, then Patel and other Trump officials learn that they can keep stonewalling without real consequences, that contempt threats are empty, that Congress's bark is worse than its bite. And that would embolden more obstruction across the administration, making oversight effectively impossible because witnesses know they can refuse to cooperate without facing real enforcement. The stakes here go way beyond just Patel's personal legal situation. This is about whether congressional oversight still functions, whether witnesses have to comply with subpoenas, whether political protection from the president can shield officials from accountability to Congress. These are fundamental questions about how the constitutional system works, and Patel's case is where those questions are getting tested right now. Think about what this moment represents in the broader context of Trump's presidency and the various ways accountability has been pursued. Courts have been issuing rulings against Trump's policies, prosecutors have been bringing cases, Congress has been investigating, but witnesses have often been able to stonewall by refusing to testify or claiming privilege or simply lying and saying they don't know things. And that obstruction has prevented full accountability from being achieved even when the underlying misconduct is documented. If Congress can break through that obstruction by actually using its contempt power, by arresting witnesses who refuse to cooperate, by forcing testimony and document production through constitutional enforcement mechanisms, then accountability becomes more achievable. The obstruction strategy that Trump and his allies have relied on becomes less effective. The walls start closing in because witnesses can't just refuse to cooperate anymore. And Patel is the test case for whether this works, because he's been obstructing so blatantly, refusing to answer basic questions about his own actions, stonewalling on files that Congress has clear authority to demand, making false public statements that he then can't explain when questioned. If Congress can't or won't hold him accountable after this court ruling cleared the legal path, then who can they hold accountable? If Patel's obstruction doesn't trigger contempt proceedings and potential arrest, then contempt authority essentially doesn't exist as a real enforcement mechanism. Here, we're watching in real time whether congressional power still means something, or whether it's been hollowed out to the point where witnesses can obstruct with impunity as long as they have presidential protection. Patel's screaming at his lawyers and reaching out desperately to Trump because he's just discovered that the answer to that question might not be what he assumed, that courts have affirmed congressional authority, that the path to his potential arrest is now clear, that all his I don't know answers and his stonewalling on the Epstein files and his false statements about investigations might finally result in actual consequences rather than just angry press releases from frustrated members of Congress. The coming days and weeks will reveal whether Congress follows through now that courts have given them the green light, whether they vote to hold Patel in contempt, whether they direct the sergeant-at-arms to arrest him, whether they actually use the inherent contempt power to enforce their subpoenas and compel the testimony and documents they've been demanding. And Patel's fate will show everyone else in government whether obstruction still works or whether accountability has finally caught up with witnesses who thought political protection made them untouchable. Stay tuned because this story is developing rapidly, and what happens to Kash Patel could determine how congressional oversight functions for years to come, and whether Trump officials can continue stonewalling or whether they'll finally face consequences for refusing to cooperate with legitimate investigations into their conduct.